All right. We have a great event today. We have Michael Metz-Topodas here with Saul Ewing, and he's a construction attorney for Saul Ewing, and he has a lot of knowledge and background in this, and so he's going to let us know a little bit about what OSHA's recent policy revisions may mean for the construction industry. Michael, I'll let you take over.
Excellent. Thank you so much, Seth. Much appreciated. As some of you guys probably know, I'm a member of KCA through Saul Ewing and also serve on the safety committee. We sort of created this idea to have a presentation about some recent developments at OSHA, and then really just leave the latter portion of our time together, however long that may be, for your questions. And I'll speak more about how we'll approach that. But I just want to let people know we've budgeted quite a bit of time for people just to ask about anything, whether it's what we talk about in this presentation or otherwise. I have entitled the talk, however, "A Change is Going to Come." There have been several recent policy revisions that OSHA has underwent, and we're going to talk about what that means for the construction industry. Just for those of you who don't know me, like Seth said, I'm a partner at Saul Ewing in the firm's construction group. Saul Ewing is a nationwide firm with offices from Minneapolis all the way down to Miami. I work out of the Philly office and as well in the Harrisburg office, and that's what brings me to events that KCA sponsors quite often. I always like to take a moment for those who don't know me just to give a little bit more about my background, only because I think it helps in understanding where I'm coming from and really, you know, where this discussion arises out of. Like I mentioned, I work for Saul Ewing as a lawyer in their construction industry. So there are the three symbols right there. As well, too, I have in addition to doing all kinds of work in construction law, I have a focus in OSHA compliance and citation defense. And for those of you who can read the fine print, that is indeed my OSHA 10 card. I actually sat through the entire class. Found it very helpful, especially given my practice in this part of in this field of OSHA compliance and citation defense. It was very helpful in terms of communicating with OSHA, which I do on a regular basis. In fact, I have a call later on this afternoon scheduled to talk with somebody, but that's a different matter. I am drawn to the Philadelphia, Pennsylvania area because I went to law school at Temple and also at Swarthmore College is where I did my undergrad. And I'm living proof that a philosophy major can actually do something other than work at Starbucks. And of course, people always want to know, well, okay, given you're not quite from Philadelphia and all of your travels and whatnot, what's your favorite sports allegiance? Well, when I was a teacher, which is one of the things I did before becoming a lawyer, I used to teach psychology, and we had a whole thing of, I did a whole unit on subliminal messages. And given that I live in Philadelphia, sometimes I like to go with the more subtle route as to talking about my favorite team. But now we want to talk a little bit more about OSHA and what has happened recently with developments in OSHA's policies and the changes that it has gone under, beginning maybe as early as 2019, but certainly around the 2020 to 2021 period. We kind of should have seen it coming. And what I mean by that is that Labor Secretary Marty Walsh, who replaced the temporary Labor Secretary before it was in place in 2020, Secretary Walsh came in 2021, was asked a year later at a budget discussion, an oversight committee hearing from Congress about, you know, how much funding he's going to need and where the priority of funding for the Department of Labor should go. And that was his one-word response. So again, I think that was a little bit of a telegraph that things are going to change with OSHA. What does that change entail? Well, it's several different parts. And the first part is something I call OSHA expansion. In other words, OSHA is going to get a little bit bigger and a little bit more significant. Well, how are they going to do that? As always is the case so often, follow the money. So what I did here is I collected OSHA's budget over the past 5 years. You can see it is steadily increasing. Don't be too mistaken by what you're seeing here, however. When adjusted for inflation, actually, by and large, the numbers are relatively flat, dips and valleys here and there. But nonetheless, there is a persistent vocalization among OSHA, as you heard from Secretary Walsh before, and others also in the Department of Labor, of trying to get more funding for OSHA. So there will be an inclination and a push towards that. The question is, what does that funding mean? We can't say it with any absolute certainty, but it stands to reason that if they're going to have more money available, they're going to have more funds to pay for the salaries for field inspectors, otherwise known as compliance safety health officers, or COSHOs. And so what I've done here is I've tracked the number of inspectors that OSHA has had in the past 5 years. We don't have 2023 data yet because the year hasn't closed out. And as well too, this some of these figures are remain to be confirmed. Getting the numbers of OSHA inspectors is actually a bit of a challenge. It's not always publicly available information. But from the reports that I've been able to gather, you can see that there's a steady staff of about 750 inspectors, a slight peak in 2020. But that's still a pretty small number. There was a period of time in the 70s and 80s where OSHA had almost 1,500 inspectors. So 750 is on the low side, to say the least. Even into the 90s and early 2000s, they were still over 1,000 inspectors. What we believe is happening from the reports that I've seen in my research and investigation is that they're trying to bring those numbers back up. And that currently the number is greater than 900 of inspectors. Now, does that mean that there's going to be this massive influx of COSHOs wandering around the nation looking to enforce OSHA regulations? Perhaps, but not right this very second. And here's why. It takes a couple of years for these folks to ramp up in training. I can say from my own experience in my own practice that I've dealt with some of the newly trained OSHA inspectors, the new COSHOs, and you can sort of get a sense that they're getting their sea legs under them, which is fine, and you sort of work with them from there. But nonetheless, once those folks do get trained, you're going to see a greater roster, a greater collection of folks who can go out and actually perform field inspections and respond to the inquiries and complaints that OSHA receives. And so as a result, one of the things we're also wanting to track here is OSHA inspections. And you can see that these numbers suggest perhaps that there's been an increase in the past few years with inspections. However, we have to look at this data in light of historical circumstances. As no one is unaware, we had a little bit of a pandemic in 2021. So the dip in the number of inspections, in large measure, is attributed to that. Obviously, we have a correlation, not necessarily a causation, but still, there was quite a number of different policy directives that OSHA implemented during the pandemic that would have led to fewer inspections. They targeted, of course, their work on the healthcare facilities and refrained from going out to other facilities, in part too, because in some places, no one was there, as we know. So nonetheless, as you can see, there's a rise in the total number of inspections as the pandemic is waning and as we're getting more inspectors into OSHA's roster, if you will. Okay? In addition, I opted to track citations. Now, this is not total citations issued by OSHA any particular year. It is just the total number of citations in its top 10 of citations, which nonetheless gives us a consistent measure of relative OSHA activity. And you can see that even as early as 2019, before the pandemic, there was a decline in the number of citations issued. That continues, obviously, unsurprisingly, through the pandemic. But 2021 was certainly, we were starting to emerge out of it a bit, but it's still relatively a pandemic year. Certainly by 2022, we were getting further and further away from the pandemic. And of course, you see the percentage of inspections rising, but still not quite at the pre-pandemic level as you see in 2018, and not even in the sort of decline that you saw in 2019. So while citations are on the rise, there's still a recovery period, if you will, from the dip that they took during the pandemic. But again, as I mentioned, these new inspectors take a while to ramp up. So we may not be seeing the effect of this increased enforcement group that OSHA has now as it begins to ramp up its hiring. Nonetheless, although the data isn't bearing out quite yet, because like I said, they're still in the process of increasing the number of inspectors and increasing their ability to go out and perform inspections and issue citations, I think we all get the point that we need to be alert that if you've got greater OSHA funding, it stands to reason you're going to have a greater number of inspectors because quite a bit of the cost of OSHA is paying the salaries of those people that work for it. Many of you on the call probably manage employees and know that payroll is a big expense. As a result, with more inspectors, you're going to get more inspections. And because a citation arises out of an inspection, more inspections means more citations. So this is the expansion that I'm referring to. There's going to be greater OSHA activity. Okay, that's fine. Understood. It could be just something that's a consequence of the pandemic. It could be a larger trend that's happening. So what? Well, now you have to make sure too that you keep in mind or what those citations are going to look like. As we all know, or as you may or may not know, there are different levels of gradation that OSHA can issue in terms of how it classifies a citation. And as well too, I gave you just a reminder of what the penalties look like. Obviously, repeated and willful are the ones that you want to avoid, and the likelihood of those become greater if you've got more inspections, more citations, it being issued. And the likelihood of repeat or perhaps willful violations increases as a result. So just something to be alert of. In light of this increase in number of inspectors and perhaps number of inspections and citations, what is it then that contractors can do, at least to respond to this component of OSHA? Well, of course, prepare. Okay. Some of you who attended some of my other presentations know I always bring this quote out when talking about how to handle an OSHA inspection. The way you handle an OSHA inspection is to prepare for it. Failing to prepare is preparing to fail. As well, too, take a look at your contract safety clauses. One of the unique features about those in the construction industry that distinguish you from anybody, let's say, in manufacturing or other industries, is that most of the work that occurs in construction takes place on multi-employer job sites. That is to say, you've got different employers all working together. Owner, GC, sub, you get it. How safety is handled among those parties can have a significant effect on the extent to which different parties are cited and to the extent to which they are liable for worker injuries or just workplace violations. And that allocation of responsibility begins with the contract. I give a whole separate presentation on this topic and how OSHA views it and handles it. They've got a policy to address this. But the overall point is that in light of greater OSHA activity, you're going to want to take a closer look at what your contracts say and how you want to apportion and handle safety on the jobs that you're working. As well, too, this could be a good time for a safety audit. That safety audit can come from a number of sources. Some of you may or may not know about the resources that IUP provides in conjunction with OSHA to be able to come out and do compliance related work in terms of viewing workplaces and identifying potential hazards. Others of you know too that you can call on your insurance broker because carriers have responsibility for workers' comp coverage and GL policy coverage. They have an incentive to reduce claims and to reduce instances where they have to get involved. One of the ways they can do that is with a safety audit. And so many brokers will arrange for that to be done for free. And then finally, you could hire your own third-party contractor. We all know that there are plenty of different safety consultants all throughout Central PA and all throughout the Commonwealth that you can rely on. Certainly, if you're curious, I've got a number of contacts of my own who can come out and help you examine your work sites, your workplace, your policies, and identify areas that are potential vulnerabilities to a citation when OSHA arrives. And like I said, with a greater workforce, the likelihood of OSHA arriving increases as well. And then finally, make sure you've gone through in that audit period process of what your policies do to ensure that you preserve certain defenses. I give a whole other presentation about what you can do to structure your safety program so that it enables and preserves certain defenses to citations that may or may not arise on your job site. So one of the things you want to do is make sure that you've got the policies and programs in place and that you're carrying them out and that you're enforcing them. Again, that topic for a whole other presentation. I won't get into detail on that unless, of course, people want to circle back at the end with questions. But I want to at least put that out there as the fact that to make people aware that you do have a response, that you're not mercilessly helplessly at the mercy of OSHA in light of its increased inspection force that we foresee coming. On top of this change in OSHA's workforce, there was a significant change in policy as to how OSHA views violations that occur at the workplace and in particular at a construction site. And this is a revision to something called the instance by instance policy. Now, instance by instance refers to issuing citations as part of OSHA's enforcement policy, and in particular, issuing those citations separately for each particular violation that an inspecting officer observes on a job site. So it allows them to sort of count in greater number the violations that they're seeing. And I'll explain in greater detail as to how we get there. But what it does, what the change in the instance by instance policy that was the hallmark of what OSHA did, is that they implemented a revision of this policy that allowed for its expanded use. Previously, it was confined to very egregious cases, very rare circumstances. OSHA loosened the reins on those constraints and allow it now to become a greater part of what the inspectors can do in terms of issuing citations. So working backwards as to what that old policy was, like I said, it was limited use in particular for egregiously willful violators. But on January 26th of this year, OSHA issued a press release and then also an internal memorandum that outlined a new set of usages and procedures for using the instance by instance policy that would take effect on March 27th. Now, the reason I put that date there is, okay, so that's now when this will go into effect, which means that any inspections that occurred March 27th going forward could then employ this new instance by instance policy. That's significant because if you fast forward 6 months from March 27th, that puts you at September 27th. And those of you who are aware of OSHA's policies and how it proceeds know that they've got a 6-month statute of limitations to issue a citation following the day of an inspection. So assuming these inspections under the new instance by instance policy begin on the 27th, you can expect to see the citations that result under this policy sometime in late September into early October in the beginning. So that's when we'll really get a sense as to what effect this policy will have, whether it's going to have an effect, whether it will affect, the nature and character of citations going forward, and to what degree. In addition to expanding the use of the policy, the first thing that OSHA did, though, is identify that it was going to only apply this policy to certain targeted hazards. So as much as it gives OSHA broad power, and we'll talk about in greater detail what that broad power can lead to, do bear in mind that OSHA's response could be, well, wait a second, hold on. We're not just giving inspectors blanket power to identify every single little instance they see on site. No, we're going to target certain hazards. What are those hazards? Well, fall protection for sure. Okay, excavation and trench safety, of course. Okay. Respirable materials, silica basically, but respirable materials and inhalation risks, machine guarding, permit controlled confined spaces, and of course lockout tagout. Now, looking at this list, you can say, okay, well, look, they confine the use of this policy to these particular areas, right? So really, OSHA isn't expanding its power, it's just clarifying it and even constraining it because the policy only applies in these areas. To which I, as a construction lawyer, say, hey, wait a minute. Some of you remember John Madden, the famous NFL commentator, would always say, hey, wait a minute. And this is definitely a hey, wait a minute moment. And here's what I mean by that. If you take a look, and some of you who are intimately involved in the safety industry know that every year OSHA puts out a list of its top 10 most frequently cited standards. Okay? And if you look at that list and the targeted list and the construction industry, here's what struck me. Fall protection in construction. Okay? So in other words, this is the most frequently cited standard in OSHA, and it is also now a standard that OSHA is targeting in the instance by instance policy. Similarly, respiratory protection, admittedly general industry, but again, we know that respirable crystalline silica is a huge part of the construction industry because we're constantly cutting or breaking concrete, which has silica in it. So again, another instance, another citation that has a direct effect in the construction industry. And then of course, fall protection training. Very often, and for those of you who've seen fall protection citations, you get one for the fall protection violation and another for the training as well. So the long and short of all of this is that you're going to see a greater effect, there is a potential statistically looking at this, that the instance by instance policy could have a disproportionate effect in the construction industry because it targets conduct that is more common in construction than anywhere else. Even assuming and separating out from the more frequently cited citations, just go back before, as we walk back here, right, from this, you can see 3 out of the 6 instances, all 50% of the things they're targeting are all in the construction industry. So you can see that it's going to have a greater effect in our industry, and even permit control confined spaces as well could be another area that also affects construction too. Although for those of you who know, as a lot of you know too, it's also an industrial hazard as well. All right, let's keep ourselves moving along. Okay, so but there are also other further limitations on where OSHA could use this policy. Okay, they're looking for anyone who has, in other words, OSHA has the authority to issue instance by instance citations for any employer who's got willful, repeat, or failure to abate violations within the past 5 years. Okay. Unfortunately, that happens with greater frequency than you would otherwise think. So that's capturing a lot more potential employers than the prior policy. As well, any failure to report a fatality, hospitalization, amputation, or loss of an eye. Now, I found this one interesting because I did not see in the policy, and if those of you want to correct me if I'm wrong, as to whether this failure to report pertained to the inspection in which the inspector wants to use the instance by instance policy. Okay, in other words, did they come out there? It would make sense that that would be the case, but I didn't quite see that in the language there. That is to say that the inspector comes out, applies instance by instance because he knows that a person knows that there wasn't a reporting, okay, as required. However, and it also could be the case that the other interpretation is the right way, and that is that there could be a prior failure to report. And that prior failure to report is now then triggering instance by instance on a second inspection, okay? I hope I've laid that out clearly. If there are questions, you can put them in the chat. Otherwise, we can circle back to that. But my point is this, it's certainly, I always advise clients, I'm sure many of you in your roles to the extent you guys have roles in safety in your organizations, certainly advise your employers to this and probably do this. Always report as required, 8 hours on a fatality, 24 hours on a hospitalization. However, we can understand that it's sometimes people forget. Why? If there's a serious instance, usually the police arrive. And if the police arrive, OSHA's probably already been notified anyway. And so we've often heard the refrain, well, OSHA's already there, on their way, et cetera. Why do I have to call it in? Now, all of a sudden, you have a reason to call it in. My point is that there's a little bit of confusion as to when this should or shouldn't apply. And you can see that this kind of technicality can lead to instance by instance. That may be an unfair application. As well, too, for any citations that relate to fatality or catastrophe, this supports my view that the failure to report pertains to the instance at hand, but it may not. And as well, too, if there are record-keeping violations relating to any kind of injury that was due to a serious hazard. And again, that's probably going to be prior record-keeping violations because you wouldn't necessarily know about any record-keeping violations in the moment that you're doing an inspection because you're sort of already there observing something. There probably is an instance leading, an event leading to this inspection, or it's a complaint. And again, then there is no injury there that's triggering the inspection. It's just a complaint. So again, this one might be one of the more controversial ones as to the factors in applying it because, again, it's quite easy to have prior record-keeping violations or citations related to injury illness that occurred previously. Okay. So in talking about what this instance by instance means, I just want to lay a groundwork for how this would apply on a citation. Some of you have seen this before. This is an example of an OSHA citation modified to make it more generic. But I wanted to establish a baseline, just remind everybody sort of where we're coming from. Any citation you get from OSHA is going to identify the classification of the violation. It can be anything from, like you saw there in our chart previously, de minimis, other than serious, serious, willful, repeat. It'll identify the regulation that's been violated, description of the conduct that was violated, what abatement measures. This one doesn't have any because it was already corrected, but that's where that would go in that space, an abatement deadline, and a penalty or fine. Okay, those are the components of every citation. It's generated by OSHA's automated system based on field input that COSHOs will do when they go back to the field, or go back to the office after an inspection. Taking a closer look, if you look at the description here, what strikes you about this one is that it talks about employees entering an excavation and climbing excavation walls. Okay, kind of a no-no for sure. But there was just a fine for multiple employees and one citation involving multiple employees and one fine. Okay. So how might this change in the instance by instance world if OSHA were to apply this policy to that prior citation? Well, now all of a sudden under the instance by instance policy, you can issue a separate citation for example, on machine guarding each particular machine that doesn't have a guard, or each particular location in an excavation where a violation is occurring, or perhaps every entry point into an excavation where a violation is occurring, or better yet, each particular employee who is exposed to the hazard underlying the violation. So what would that look like in an example like this? If OSHA were to arrive on a site and see something like this, and all the other criteria and factors for applying the instance by instance policy would be met, and certainly here we have an issue of fall protection, so we're covered there, and assuming that this employer had prior record-keeping violations for serious hazards and injuries, then here the inspector would count 1, 2, 3, 4 violations. Maybe more, because there could be things outside the scope of this picture. But right now we've got 4. So what I want to do then is show you how that would look old versus new. Old was that citation I presented before, which just had 1 fine, 1 citation for multiple employees being exposed. So in that instance, you have a serious violation. Here we're 501 fall protection, okay, times, well, 15,000 maximum penalty equals 15,000 maximum penalty. Some of you know too, OSHA's got a field manual. They can downwardly adjust based upon degree of harm, size of the company, prior history, et cetera. But right now that's the maximum penalty, okay? But if the instance by instance policy applies, you got a serious violation times the maximum penalty times 4 employees. I'm sure you all predicted where this was going. Some of you had done the math, $60,000. It's a whole new ballgame, okay? There's a whole different way you approach, and I can tell you from my practice, a $60,000 penalty, and that's just 1 photo. Who knows what else could be on that job site? A $60,000 penalty as opposed to a $15,000 one. And also much harder to mitigate in terms of your discussions with OSHA. So what does this all mean? I cut from here various quotes, both in OSHA's internal memorandum and its press release, talking about why it implemented this policy. To OSHA's credit, they weren't really hiding the ball on this one. And you can see it is really a way to target folks who they think don't get it. OSHA thinks doesn't get it. Those who don't get it, and those employers, who OSHA thinks will only respond to additional deterrence. Again, you can see that the policy was meant to have a deterrent effect. It was meant to give OSHA another tool in terms of enforcing and carrying out its mission to create safer workplaces. They have an understanding that this new enforcement guidance will make penalties more effective. In other words, OSHA believes that these increased fines, increased penalties will create greater compliance. And there is a belief that citations are necessary here, both in terms of number and associated fines, to ensure that employers are creating safe workplaces. So it's pretty clear that OSHA has, you can see, I think, sort of where it's coming from in this, the mentality that greater workplace safety arises out of more frequent citations and higher number citations. This is why people you saw some of the literature that came out about this. That was the initial reaction among safety professionals and those who practice in OSHA compliance and citation defense. That's what we all sort of realized, like there is a potential for this, the limitations notwithstanding. Okay. I also want to take a moment too to talk about grouping. OSHA had a policy about how it groups citations. Some of you may have seen this if you've ever dealt with one, where you'll get one particular citation for a certain fine or certain dollar amount, and then 2 or 3 under it. Usually it'd be like citation 1, item A, or sorry, item 1A, 1B, 1C. B and C have a no penalty fine, and they are just different violations that all grouped together because it makes sense to do that. OSHA realized that in that inclination to group things, that could run counter to the instance by instance policy. So what do they have to do? They had to revise grouping as well, so they wouldn't have that conflict of policies. They wouldn't have instance by instance constrained by grouping. So, like I said, previously OSHA could group the violations all together where there were multiple and related. Like I said, item 1A, 1B, 1C. And as well too, if one penalty, one abatement, would satisfy, then you would get the other violations where they're noting that, hey, we observed this violation of another regulation, another standard. We're going to put it all together here because it all makes sense. They're all related. The revised policy is a little bit different. Again, done by a unilateral revision and an enforcement memo. And it says COSHOs may refrain from grouping. So while they had a policy about grouping, now it says, well, you don't have to do that if the worksite conditions give rise to separate and distinct violations. Translation, where it's an instance by instance citation, okay? Or you have different conduct giving rise to the violations. Again, instance by instance, okay? For example, in our machine example, right? Each different machine technically could be a different conduct. Each person in an excavation technically is different conduct, okay? Each area where an excavation perhaps does not have the spoil pile separately away from the excavation, or is too deep without sufficient cave-in protection. Each one of those could constitute a different conduct. Those don't need to be grouped anymore. On the other hand, OSHA said, but by the same token, if you can put multiple other than serious violations together to lead to a serious violation overall, then go ahead and group COSHOs, okay? So you can see, like, either way, it's like heads I win, tails you lose, right? When we group to make sure that we have a serious violation. And when we don't group, it's so we can have multiple serious violations and not lump them all together, okay? I want to take a moment too to talk about another change that may not have caught everyone's attention, but a change in the Severe Violator Enforcement Program. This is something OSHA created, years and years ago, and it was meant to allow for supplemental measures for particularly repeated and willful violators, or people who just refused to take any of the abatement measures that OSHA directed. Enrollment in the program had many features, all of which we would consider unwanted. This isn't one of those OSHA programs you want to get into. You're put on a public list, so everybody knows you're there. You can imagine what effect that would have on recruiting, on bidding, on public projects, for those of you who do that. Not a good thing to be on. As well, too, it allowed OSHA to do follow-up inspections at both the incident site on a citation or any other site, any other establishment related to an employer. 3-year policy unless you can negotiate some kind of enhanced abatement. Okay? So essentially, the old SVEP applied to employers who had fatalities, 3+ hospitalizations, or other egregious matters. OSHA modified that, and it's sort of a sleight of hand twist of the language, where, and as well too, any employers with the potential release of hazardous chemical or finally 2+ willful repeated violations of the high emphasis standards. You know that OSHA has different emphasis programs, fall protection being one of them, and others, other potential hazards. Again, if you had 2 willful repeated in those areas, you could also get on the list, the program. The new policy now changes things a bit. Now it's any fatality or catastrophe with 1 or more willful or repeated and a failure to abate for a serious violation that leads to death or 3+ hospitalizations. Okay, so they're kind of tweaking the language there that allows them to put people on the program. They're expanding the reach of this program. Or any non-fatality with 2+ willful repeated or a failure to abate, not for a high emphasis, but any high gravity serious violation. And so that high gravity serious violation has a much more broad definition under the policy than before on the emphasis program. And so in that respect, then essentially what you've got, without getting into the details of the language here, you've got an expansion of pathways, avenues for folks to get on this policy. Oh, and of course, yeah, while we're at it, any egregious violation, which I don't think, if I recall looking at the policy, had a particularly clear or solid definition. So with all of that, obviously the ways to get on the program have been easier. And like I said, it's not one you want to be on. So, and so you can see that there's a potential for greater involvement of OSHA in the operations of businesses, especially in high-risk industries like construction. In light of all of this, the expansion of OSHA, the instance-by-instance policy, the change in grouping, and of course now this change in Severe Violator Enforcement Program, what are the defenses then? What can companies do in response? Okay. Well, first of all, like I said, continue to contact your insurance broker. Definitely a person you can go to for not only safety audits, but also just making sure that they can provide various literature, and I've seen them do this, about safety at the workplace, and in particular, up-to-date safety policies. Now, bear in mind, those are template policies, one size fits all. Usually when I'm advising clients, I will let them know, okay, that's great, you got that from your broker. Let's take a closer look at this so we're not putting things into your company's policy that don't need to be there. For example, a roofing subcontractor does not need a section in its safety handbook on excavation safety. Okay, doesn't need to be there, and vice versa. A site contractor doesn't necessarily need much in the way on fall protection, unless perhaps there might be certain activities they engage in, but you get the point. As well, participate in safety programs. Seminars like this. KCA, as you know, too, for example, circulates once a week, particular important toolbox talks. Another great resource that you can use to demonstrate your commitment to safety. When you talk about, I talked before about structuring your safety program to provide defenses, effective toolbox talks are great because they're a constant reminder to your workforce about your policies and about different hazards in the workplace. And if properly documented, it can be a great way of responding to OSHA when it says, well, you know, how did you protect your workers? Well, you have a nice stack of toolbox talks with everybody's sign-in on it one way or another, electronically or otherwise, and showing that you are committed to making sure that your workforce is properly trained and understands safety. Of course, if you've got a safety consultant or any kind of safety coordinator on your workforce, you want to have that person involved. And don't forget your counsel. Don't forget your lawyer. That is somebody who can continue to advise on how best to structure your safety program in anticipation of these changes that are occurring at OSHA, and in a way that will, like I said, preserve those defenses to citations that you can then use should you be cited by OSHA, either on the negotiation side, where you're negotiating reduced penalty, reduced classification with the area director, or if that doesn't get you where you want to be, you take it to a hearing, essentially a formal trial on the citation. I've done several of those myself, and happy to speak more about that as we get almost to the end here. So with all that in mind, this is the point where we ask, I'm happy to take any questions from folks. I know we budgeted an hour. I'll take questions as long as people have them. If we want to end early, that's fine too. The only caveat I'll give about this are two. One, anything that I say here is not legal advice, so I can speak generally about policies and about general circumstances, but as to your particular fact-specific concerns, I may not be able to do that. And more importantly, I just wouldn't be able to have a full set of information. And that said, too, because we're having a wide scope of different questions involved, I may want to just reserve the right to go back and double check a few things if something comes up that might be outside the scope of this presentation. Although, like I said, I welcome that, and I'll look forward to hearing that. So I'll open the floor to anybody who has questions. You can take yourself off mute. I think Seth has probably disabled the host mute button, and I'm happy to answer anything, any questions folks may have about either what I've presented or anything about where OSHA is going or any kind of OSHA related or safety related concerns.
I have a question. This is Howard Bernstein with Penn Installations. Can you hear me okay?
Yes, Howard, how are you?
I'm good. Thank you for doing this. Appreciate it very much. You had mentioned having a safety program that preserves defenses. Are you able to give a couple examples?
I'll give one. In particular, not always the most favored defense for OSHA, but it's called the unpreventable employee misconduct defense. Essentially, I like to say it's when an employee goes rogue, does something completely prohibited under any of that employee's training or the company's safety policies. And it's certainly, we can understand this all the time. People do things that they're not supposed to do. OSHA's response is, that's great, but did you do everything, you the employer, to make sure that person didn't do that? OSHA sort of takes a view that the employees don't have the same knowledge the employer does, and therefore should be treated as such. As a result, in order to bring about this defense, you need four components. One, you need a comprehensive safety policy. In other words, do your policies address the hazards that happen to have been cited? So that's why I said before, you want to make sure that your safety program and policies are targeted to the hazards that your workforce is encountering, so that when you want to employ this defense, you can say, yeah, of course, our policies are directly related to prevent the very citation that occurred. That's step one. Step two, training. Are you giving adequate training to that worker? Has that worker received general training on different safety policies that were at issue in the citation? Not only that, have they received job-specific training? As we all know, no two sites, no two construction sites are alike, and sometimes no two activities on any given day can be alike. So has there been specific training to that employee to prevent the very hazards that were encountered? So that means that's why those toolbox talks are so effective, because you're, again, providing that daily training. It can be formal, it can be informal. I recommend both. They can be anything from just a reminder about, for example, how to put on your personal fall arrest system, your harness, okay, to a 3-hour class from a safety consultant on fall protection and the different methods of fall protection. So any of that is there. The third part then is communication of the violation of the safety policy to the employee. That's the supervisor saying, where's your hard hat? Where are your steel toes? Where's your harness? Don't go in that trench, etc. Don't go in that excavation. It's over 5 feet. We haven't put in cave-in protection, okay? Any of that communication of those policies. And then finally, enforcement, consistent enforcement. Anybody who violates a policy, the consequences are progressive and handed out consistently, okay? So there's no exception for your best worker or anything like that. Finally, with all four of those, as I'm sure you're gathering, Howard, you need a robust set of documentation. That's why one of the things I advise is for safety directors or superintendents or those who are on site, making sure that they've got an iPad or some other device. I mean, you can do it manually with a clipboard or whatever, but an iPad's great because you can design an entire application where that superintendent can just punch in, told Sue, make sure she has her hard hat on, etc. And then it just goes uploaded right to a database. And now if Sue is exposed to a hazard and there's a citation as a result, and it turns out that you the employer believe that Sue just didn't listen to all the training that was provided, you have a record, a database of all the different times Sue was reminded, wear your hard hat or don't go in this excavation, etc. And that body of evidence, that documentation is a good way of establishing, or is the way to establish that defense. The bigger the stack of documents, if you will, or database information, the better. So that's one example, Howard, of what I mean by structuring your safety program to employ certain defenses. I could go on and on and on. Seth can tell you, he saw my presentation at GOSH last year. I covered it. And listen, Howard, if you want, I can dig that up and send it to you as a PDF or to everybody if you're all interested.
Again, everyone will receive the video. I'm recording it, and I'll be on our website, and also I'll send it out to the people that register through Eventbrite.
Yeah, and I meant the other one, Seth, that I did, back in the fall too. Happy to send that one too.
Oh, right, correct, great.
So yeah, great question, Howard. Thank you so much.
Thank you.
Hey, Michael, it's Darren Reck. Great
Hey,
presentation.
Darren.
Appreciate it. Hey, question for you. You know, you mentioned Gosh last fall and we were on the panel together. And is there anything changed from OSHA standpoint? You know, we currently have two projects where our role is, we serve as the agents, construction manager, not at risk, but we don't hold the contract. So we're an agency role. Anything new or different from that standpoint from OSHA's perspective that, there was how liable or how much involvement do we have, Alexander in this case as an agency CM, as far as making sure people, given instructions and, we don't hold the contracts, but, we make the recommendations, but, I'm just wondering if there's anything new from that arena, with OSHA.
Great question. That pertains to something called OSHA's multi-employer liability policy.
Yeah.
That's the one where, as we all know, right? OSHA shows up. You see, we have owner, GC, subs, CM, all kinds of people to cite. One of the things that OSHA does actually is for a particular violation, they literally will cite everybody. And not only that, they'll give the same citation to the GC, the CM, the subcontractor, and sometimes even the owner, which is astounding because, the one I saw had to do with emissions from a portable concrete, a cement or concrete mixer, excuse me. And of course, that's, the masonry sub was using that. And so the violations that the GC potentially could have had or the CM were far different than the direct employer. But nonetheless, OSHA doesn't really discriminate. But how that all plays out depends upon a number of factors. And that can go to, that's what I meant before, Darren, about looking at your contracts. It can also go to the relationships among all the parties, the prior safety records, and how things are being carried on the job site. With all of that in play, and I won't get into the multi-employer, again, I actually got a whole nother webinar on that one too. But be that as it may, so far, Darren, I've yet to see any changes in that policy. That said, you bring up a good point. Now I'm going to be alert for that because who knows if they're going to try to change that one. Nonetheless, like I said, they use that policy to cite everybody. I think OSHA is probably pretty satisfied with the result it's able to obtain under that policy, but I've seen no changes in it. But it is incumbent upon employers to know all those factors in determining what their responsibility on a multi-employer site might be.
Great. Yeah, appreciate it. Yeah, we certainly have more of those projects seemingly now than we've had in the past. So it's on our radar. Appreciate it. Thank you, Michael.
No problem. No problem. Happy to help.
I have a question. With OSHA putting more attention on penalties, are they going to use drones more? Is that going to be something that's going to be a valid tool? And just because I'm wondering about, everyone knows that videos can be fudged, and how's that look in attorneys' eyes?
Two different issues. One is the issue on drones. One's the issue on videos. I can speak to them both. One, the latter, more practically speaking, Seth, at least from my own experience as a litigator, and I'll explain what that all means. But on the drones issue, this actually came up in a presentation I did back in 2018. There were rumors that OSHA was using drones. There are two things in play here because in particular for a private project, and I've actually checked with my real estate colleagues on this one. You own in your property, from the property footprint all the way to the sky, okay? And you may say, wait a second, why do planes fly overhead? Well, you yield a portion of that property to the government for the best interest of the public to have planes fly over. But in doing so, the government says, well, we're going to regulate that for you, make sure that it's safe. It's called the Federal Aviation Administration. Therefore, all those drone flights, and any of you who do droning as a hobby, if you will, know you've got to register any one of those flights with the FAA. You got to have a flight path approval, all that stuff. So for OSHA to be able to use drones, they got to go through all that process. And so far, I haven't seen them. They have a few. I think they have a fleet of like 11, which isn't very many. And not even sure how many people they have trained on it. However, I guess theoretically with the greater number of inspectors, they might have more availability to do that. Nonetheless, as some of you know who may have experienced this, OSHA's got a far easier way of handling this. I've definitely seen instances where if you've got roofers performing work on a 10-story building, OSHA will go find the nearest 20-story building and get their photos looking downward from there. So that's a lot easier than getting an FAA license and flight plans and all of that. So I don't know if the drones are going to come into play. And your second question was, on the videos. Yeah. Typically, and whenever I conduct any kind of litigation, and I've done this with OSHA too, I insist that you get native file production. Okay, what that means is that like if I'm collecting emails, to the extent I'm going to get emails between the area director and the inspector, I don't want a printout of their email. I want the actual email. Okay, or I want it given to me in a way that preserves all the metadata on that email. If they have any photos, I want the digital photo with all the metadata. If they have any video set, I want the video with all the metadata. That will let me know if the video has been manipulated. And that's why you ask for it. Because you're right. You know, back in when we were in high school, or maybe when I was in high school, if you wanted to edit a video, you had to like get a VHS camera. I don't know how you would even do it back then, right? And the 2 tapes and the whole bit. Now, I mean, my goodness, anybody can do it. It's all digital. So it's a much different world we live in, but should be a digital signature to that, unless they're really sophisticated. And I don't see OSHA having that level of sophistication to manipulate videos. Now, could an outside third party do it? Sure. And then you get into chain of custody issues to the extent that OSHA wants to use an outside video against somebody. So.
Thank you.
Yeah.
Well, if there's no other questions, anyone else?
Yeah, last call at the bar.
Well, with that, Michael, thank you for sharing your expertise on this topic. And on behalf of the KCA Safety Committee, we thank you for being here today and spending your time with us.
Always happy to do it. Thank you so much, everybody, for all your great questions. And please don't hesitate to reach out anytime if you have any other questions on any of this stuff. I hope I've convinced you enough that for me, it's fun talking to OSHA, but it's also serious because, of course, these are our workers. As so many of you have told me, this is your family. At the end of the day, that's the most important thing about safety. OSHA regulations and all that stuff, that's one level. That's the more important level. If you keep that in mind, as I've heard over and over again, all kinds of meetings with KCA and other organizations, you're going to be fine.
Thank you.
Thank you, everybody.